This was supposed to be about judicial accountability, but Senator Mazie Hirono just exposed what she says is something far more dangerous. In a blistering takedown, she accused Republicans of using impeachment to intimidate judges who rule against Donald Trump. And then she flipped the spotlight onto Justice Clarence Thomas.
Thank you. I'm really glad that that the chair and others have expressed concerns about using facts in order to make decisions. So that's good. So let's look at the facts. Let's talk about those facts. Chief Judge Boasberg issued non-disclosure orders for subpoenas seeking telephone records. My Republican colleagues object to the judge's decision. But then he issued these orders. When he issued those orders, he did not know that the phones belonged to senators because nobody told him. And that was the longtime DOJ practice at the time of his decision. Jack Smith testified to this under oath before the House Judiciary Committee last month. And if we have questions about that aspect of what was going on, yeah, we can invite Jack Smith to come and testify in an open hearing as he has offered to do. Meanwhile, as for the judge, he was told that President Trump or those who tried to help him overturn the election made or received calls from these phone numbers on January 6th or shortly before. Courts are required to issue non-disclosure orders when there is reason to believe that not doing so would lead to witness intimidation or evidence tampering. That does not mean, as Jack Smith testified last month. In fact, here's his testimony. This is his transcript of the testimony he provided to the House Judiciary Committee. He testified that the senators whose records were seized, he was not testifying that they were the ones who would tamper with evidence or intimidate witnesses, only that someone would. Instead, again, according to Jack Smith's sworn testimony, non-disclosure orders were sought because President Trump repeatedly tried to intimidate witnesses. We have all been witness to the fact that President Trump goes after people he doesn't agree with, and he is very busy targeting people. We know that. So if my colleagues want more answers, they should invite, again, Jack Smith to testify publicly as he has offered to do. Or at the least, they should read the transcript of his sworn testimony. We care about facts? Well, hey, here are facts that he's providing. If my colleagues are looking for someone to blame for their phone records being seized, they should blame President Trump, who tried to overturn an election on January 6th and called or had someone else call the senators in the process. But this impeachment crusade, this hearing, is not about supposedly judicial misconduct. It is about intimidating and threatening judges who have the temerity to apply the law to Donald Trump and render decisions that Trump doesn't like. Come on, let's face it. We all know that President Trump doesn't think that the rule of law applies to him. He can do anything. That's what he said. So this hearing is for show. And who's the audience? President Trump. If the standard for impeaching judges was that they issue decisions we disagree with, then I would call for the impeachment of the justices behind opinions like Citizens United, Dobbs, or the hand-picked judges in Texas who are the targets of so much judge shopping. But a judge or a justice's decisions should not be the basis of an impeachment, which is something the Senate has understood since the Jefferson administration. And that's why I, and so many of us, we don't call for judges to be impeached based on how they do their jobs and the fact that we disagree with how they do their jobs. And if we want to talk about judicial accountability, we should conduct further oversight of Justice Thomas's failure to disclose the many gifts he has received as an example. That's just one example. In the meantime, let's stop with these kinds of hysterical, and I would say dangerous attacks on the judiciary. And as for Judge Boardman, her sentencing decision is on appeal, and as the Chief Justice Roberts has said, the appellate process is the appropriate process. And that is exactly what is happening. I am running out of time, but I just want to ask Professor Vladeck. So we're sitting here spending hours talking about impeaching judges whose decisions we don't agree with. And there has also been criticism of Judge Boasberg for how he assigns cases in the U.S. District Court in D.C. And I think that there are guidelines on how he does that, and it's, I think, random assignments. And that's different. For example, I would say, maybe you can explain further the difference between the random assignments we're seeing in D.C. and the judge shopping in certain district courts within the Fifth Circuit.
Sure. I mean, Senator, just very briefly, because I know time is short. So the D.C. District Court has a random assignment process. I believe this committee is in possession of a letter from the administrative office that walks through how that process works specifically in DDC. There's a Fox News story by a reporter named Brianne Depish that I think concluded that, in fact, Judge Boasberg has a disproportionately low percentage of cases challenging Trump administration policies. That is different from at least what is the one district court left that has judge shopping, the Northern District of Texas, where it's still the case that 100% of cases filed in Amarillo, for example, are assigned to Judge Matthew Kaczmarek, or 100% of the cases filed in Wichita Falls are assigned to Judge O'Connor. And, Senator Hirono, I think it's a relevant point because even as I think, have visibly been one of the loudest public critics of the practice of judge shopping, never did I call for the impeachment of Judge O'Connor or of Judge Kaczmarek, even for indulging this process, even for denying motions to transfer, even in the case of Judge Kaczmarek for taking a shot at me, right? This is how the court system is supposed to work. When things go wrong in that process, we appeal or we reform. And just really briefly on the call records, that to me is the productive part of this conversation. If a majority of this committee, if the full committee thinks that the targets of call record subpoenas have a right to be notified, then so be it. And then that's a conversation about how we can change the law. That's a conversation we've had about foreign intelligence surveillance for the last 15 years. So I think we're trying to use the lens of judicial impeachment to get around the fact that there are actually meaningful substantive policy questions here that are much more fruitful to discuss.
Mazie Hirono wasn't just defending a judge, she was defending the rule of law itself. Her message was clear. Impeachment is not a weapon to punish judges for doing their jobs. She walked through the facts, cited sworn DOJ testimony, and dismantled the claim that this was judicial misconduct. And then came the turn. If Congress truly wants judicial accountability, Hirono said, start where the evidence actually is. Undisclosed luxury gifts, ethical failures, a sitting Supreme Court justice. This wasn't just a rebuttal, it was a warning, because once impeachment becomes political revenge, no judge is safe, and neither is democracy.